Alright, so the chair of our panel for this session is Professor Margaret Leung, who's Professor of Law at the Northeastern School of Law. And she's also a distinguished Professor of Public Policy. And she's also a Brown alum, so we're very happy to have her back here. So, Professor Leung.
I have to say, when I got the email, I had to say yes, because one, I was born in Hong Kong and moved to the US when I was 8. And two, I went to Brown, graduated in '79. So, and then I have to also, I keep on sharing my conversations from lunch. My lunch companions must be like horrified. But I love coming back, and I love meeting and talking with the students. So, and I love this conference because I'm amazed at both the quality and really the ability to bring together an international conference strictly by undergraduate students. I could never have done that when I was at Brown. And then one of you at my lunch table reminded me that at the time when I went to Brown, I probably didn't have all the technology at my disposal to plan this conference, and they're absolutely right. Just to kind of share a story, I went to college carrying an Underwood electric typewriter. Yeah. And that was my big, my big kind of, oh God, I can get my papers done because I've got my electric typewriter. So if I were to plan this conference back in the 70s, I would have had to type out the letters, and one of you in the lunch table said, oh, and then fax it out. I said, I would have to bring it over to the post office at Mom's house, have it mail, wait 6 weeks for a response. Anyways, you get the picture. But I think that it is wonderful to have such a good conference because, and the technology that enables it, and it really gets down to, yet again, talking about democracy movements and the ability to really organize and to build coalitions. And when you do have that technology at your disposal, I mean, a lot can be done, as evidenced by this conference. So, but I'm going to just now turn it over to our speakers, and we're going to start with Professor Flaherty, who is the director of the Latner Center for International Law and Justice at Fordham. He is now, I think, visiting at the Woodrow Wilson Center at Princeton. He's going to kind of give the groundwork on the one country, two system and give some prognosis. And then he'll be followed by Professor Rezvani, okay, who is a professor at Dartmouth, and he'll be speaking about Hong Kong and partial independence and drawing on his comparative research on other semi-autonomous regions around the world. And finally, we'll have Professor Janny Leung, who will draw on her current work and touch on really issues of access to justice, delivery of justice in bilingual courts like Hong Kong. And we'll wrap it all up by hearing from our prior keynote speaker, the Honorable Kwok, and he's going to wrap it all up for us with several comments and raise additional questions. So why don't I turn to Professor Flaherty?
Well, thank you very much, Margaret. And I'd like to echo her sentiments. I am just incredibly impressed that this is a student-organized conference because the quality and turnout is exceptionally impressive, and actually in some ways it's a condemnation of your professors. Your professors at your various schools should be doing, and in fact I was struck when Dennis Kwok said this was one of the first conferences he had known of or been to concerning Hong Kong in 15 years almost. And I think that this conference shows that not only is it important on the merits, but there's actually a great demand. So go back to all of your schools and tell your professors that Hong Kong should much more be on the radar screen. Now, I have 2 passports. I didn't give any of them away. My other passport is from the Republic of Ireland. And given what day is happening on Monday, I was trying to think of the connection between Ireland and Hong Kong, apart from just oppressive British colonial rule. And it put me in mind that the best t-shirt I ever got is The Connection, because I don't know how many of you know of this place, but there's a pub on Peking Road off Nathan Road in Kowloon called Delaney's.
Yes.
Wow, this is, I didn't and at least at the time of the handover, they had another pub on the Hong Kong side. And so in 1997, they were selling t-shirts that said, "One country, two pubs." So that's the connection. Although, unfortunately, I think the one on the Hong Kong side closed, which does not bode well, I think. Let's not reach out. So let me start with a caveat, which is that I come to issues concerning human rights, rule of law in Hong Kong very much as a generalist. I teach international human rights. I'm an international human rights advocate. I've done over a dozen missions in many different countries, some in East Asia, but in Europe, Africa, etc., on a whole range of issues, from classic torture and preventative detention issues to affirmative rights, right of education, other social rights issues. And by the way, I should say I've also done a lot of work with regard to the United States adherence to international human rights standards, particularly post 9/11. So I come at this from that perspective. That said, I do have at least, I think, some background relevant to today. First of all, my current concentration is with regard to human rights in the mainland, with human rights in China. I actually co-founded a small NGO, which I hope you guys Google and then like us on Facebook, called the Committee to Support Chinese Lawyers, which attempts to aid lawyers who are persecuted in China. And indeed, there's a sibling organization in Hong Kong called the Chinese Lawyers Concern Group, and so access their webpage as well. I also, for the last 10 years, have taught about human rights in China at the Woodrow Wilson School at Princeton. In addition, with regard to Hong Kong in particular, I have worked both with my Human Rights Center and the New York City Bar Association on issues concerning judicial independence and the rule of law in Hong Kong. In fact, my introduction to those issues was on a human rights mission to Hong Kong in 1998 in the midst of the whole right of abode controversy. And so have kept up with Hong Kong to an extent since then, but I have to concede that it's dropped off to an extent off of my radar screen as well, and so this is a wonderful opportunity to get re-energized about engaging with Hong Kong. And then finally, friends, family, and students have all sorts of connections to Hong Kong. Many of my students, my own students, particularly at Princeton, are from Hong Kong. And my family is, my wife is ABC. Most of her relatives are from Fujian, but a few, wound up in Hong Kong as well. So, what I want to talk about briefly is three things. One is talk about a context that's even more general than the context I think that we've heard so far. And second, to talk about what is ostensibly my area of expertise, which is the legal protections for the one country, two systems idea, particularly with regard to fundamental rights, the rule of law, and democracy. And then, and talk about that in relation first with regard to international law, and then with regard to, if you will, domestic Hong Kong law, and particularly the basic law. And then finally conclude, if time, and I'm trusting Margaret to keep me honest here, if there's time to talk about some suggestions for advocacy going forward. So, context. What are the stakes involved with Hong Kong, and what is at least my sense of the status of Hong Kong with regard to what Dennis Kwok referred to as core values? Well, the stakes as important as Hong Kong is, and I know many of you are from Hong Kong, as important as the fate of the 6 million people in Hong Kong is and those in the region that are dependent on Hong Kong, I'd like to suggest that the stakes are even larger. That rather than talk about one country, two systems, one way to think about the importance of Hong Kong is one region, two visions. And the one region is East Asia. The two visions actually are another form of the competition between Singapore and Hong Kong. Those two cities in some ways are representatives of two different visions for East Asia. So what's the Hong Kong vision? And the Hong Kong vision is something that is also evident in Taiwan, in South Korea, to a lesser extent Japan. And it's a vision that one might describe as thick rule of law. Rule of law not just with regard to the neutral application of legal standards, especially in the business realm, but also a conception of the rule of law that safeguards fundamental rights, including rights of free association and free expression. And beyond that, a notion of democratic self-rule. That is a thick vision of the rule of law, and that is the vision for East Asia that Hong Kong and Hong Kongers offer, and that has also been implemented in Taiwan and in South Korea, and as I say, in somewhat trickier fashion in Japan. What is the Singapore vision? The Singapore vision is a vision that one can attribute to Lee Kuan Yew, and I would submit, I agree with Ian Baruma, that it's not so much a Confucian vision as a British colonial vision, which is a vision of the rule of law that's thin, that's de minimis. And what is that vision? It's a vision of independent judiciaries applying neutral legal rules with regard to what? With regard to the economy, with regard to business, with regard to commercial transactions, but not extending to the protection of fundamental rights like freedom of association, freedom of the press, etc., nor extending to an idea of democratic self-rule, let alone multi-party self-rule. So a vision of one-party self-rule, one-party rule where there is very limited and constrained freedom of press and expression, yet there is rule of law that is sufficient to conduct business. So those are the two visions. Now, for years I had said that I thought that that was what the Chinese leadership had been shooting for. Was really that their inspiration, was not Mao, not even Deng Xiaoping, but really was Lee Kuan Yew. And folks had often poo-pooed that, saying, well, surely they must realize that that cannot be replicated on a massive scale of 1.3 billion people. You can sustain that model, or that model is sustainable in a small city-state. You just can't possibly sustain that model in a country as massive as China. Well, whether that's true or not, and I believe it is true that it's not sustainable for a country as massive as China, I don't think that that is the thinking in Zhongnanhai. And I think that the last two iterations of leadership, including this iteration of leadership under Xi Jinping, is shooting for something exactly like that model, or not exactly like that model, but largely like that model. Singapore is still, much better on many of these matrices than China is, but the same basic vision of one-party rule, limited fundamental rights, but thin rule of law for the purposes of business is, I think, the vision that the current leadership is trying to implement. As witness the Xi Jinping effort at cracking down on corruption, and indeed talking about constitutionalism and talking about rule of law in that regard, not more generally. Okay, so the fate of Hong Kong, I think, is very much tied into the fate of how governance is going to work in East Asia generally. So how are things going in Hong Kong? Well, here, I'm happy to say that the keynote speech basically stole whatever thunder I had in that regard. I pretty much, in fact, I was happy not having followed Hong Kong exceptionally closely, to have what my own observations were largely confirmed by Dennis Kwok. So just to go through that very briefly. Oh, and the one other thing I just want to say about China, which is also to confirm what I said, is having looked at China, China actually was very much progressing in terms of the rule of law. In fact, given that there was no legal system in China in 1980 to speak of, which is basically true, the fact that the legal system as it exists now is a tremendous accomplishment. But I am of the school of thought with various scholars that think China has taken a turn away from the rule of law, starting just after the turn of the millennium. And one of the markers of that is a quite brutal crackdown on a small group of civil rights and human rights lawyers that was coincident with the Arab Spring, which led to disappearances, torture, and other just brutal human rights violations. That is just one other bit of evidence for my grander vision. Now, with regard to Hong Kong itself, I think 15 years in, I think one way to characterize what Dennis Kwok said is the status of Hong Kong is better than feared, but not quite as good as hoped. Much better than feared, but not quite as good as hoped. What's good, the economy, I think, is free, as witnessed the various assessments. Also, generally speaking, especially compared to China, the protection of fundamental rights, particularly the direct protection of fundamental rights, in other words, rights not being directly violated by the government, either government, are still fairly robust. And indeed, I think the legal system, I agree, is one of the best in the world. And I think arguably could even be getting better, because I'll be very interested to hear what Professor Leung has to say about thickening the commitment to the rule of law by translating into Chinese the common law legacy of case law and laws, which was something that the SAR government was starting to undertake even 15 years ago. What's the bad? Well, we've heard about some of the bad. One is the erosion of free press. The other is I don't want to kind of say stillbirth yet of complete universal suffrage and democracy with regard to both LegCo and the chief executive, but certainly the ongoing delay with regard to democracy. That has been a signal disappointment in what was originally envisioned. So what are the legal protections? Moving on to my second point. Well, in terms of international law, the legal protections are a combination of the Sino-British Joint Declaration and the International Covenant on Civil and Political Rights. The Sino-British Joint Declaration of 1984, despite its name, is a treaty. It's a treaty under international law. It's a treaty under the Vienna Convention on the Laws of Treaties. It's a solemn treaty, an international agreement between the United Kingdom and the People's Republic of China. And under that treaty, China pledges to safeguard various enumerated fundamental rights, including rights of free association, free expression, etc., to maintain the system in China. First of all, there's the overall pledge of one country, two systems, but what does it mean? One is to maintain the free market economy, but the other is the legal system, but in a thicker way, to include, beyond the Singapore model, fundamental rights. And that's expressly in the Sino-British Joint Declaration. That is an international undertaking of China. The Sino-British Joint Declaration, quite frankly, is a little less good on democracy. It's pretty vague and pretty tentative with regard to democracy. And if you read the annex, and I don't have time to go into it, it's very diffident on selection of the chief executive and pretty vague on elections. It talks about elections of LegCo, but it doesn't necessarily say one person, one vote elections of LegCo is the ultimate goal. There, the basic law is going to be much better. How does the International Covenant on Civil and Political Rights come in? Well, that is also something that is China pledges under its treaty with the UK to maintain. The ICCPR is something like a modern version, if you're not familiar with it, with the US Bill of Rights. It is one of the foundational documents of the modern post-World War II human rights movement. The United Kingdom had signed and ratified the ICCPR, and in doing so, it applied throughout the empire to the extent it still had colonies, which meant when the UK signed and ratified it, it applied to Hong Kong as well. In the Sino-British Joint Declaration, China pledges to maintain the application of the ICCPR to Hong Kong. So China has signed but not ratified the ICCPR, so it does not apply in full anywhere in China other than Hong Kong. the ICCPR goes well beyond even free speech rights and free association rights. It is criminal due process rights. It is really the kind of array of rights you would be familiar with from the US Bill of Rights. What it also guarantees, and this gets very technical, is free elections on something like a universal suffrage, one person, a right to be elected and a right to participate in elections. Now, there is a problem because Britain took a reservation to that element of the treaty with regard to Hong Kong. It's Article 25.2. However, and in fact China maintains, see, Britain didn't want to apply it to Hong Kong, and so if we're applying the ICCPR to Hong Kong, well, there's no international basis for universal suffrage or one person, one vote elections ultimately. Actually, the committee that is charged to implement this treaty, the Human Rights Committee of the United Nations, disagrees with the People's Republic of China. So what we have is at least a persuasive interpretation that China, through the Sino-British Joint Declaration and thus the ICCPR, as a matter of international law, must guarantee an array of thick fundamental rights, including electoral rights. And China cannot, as a matter of international law, say that this is not any other country's business as a matter of domestic sovereignty. It gave up the right to say that when it signed the Sino-British Joint Declaration. So, now, the bad news is that the processes for international enforcement, like much of international law, are pretty thin. There is no right of individual petition for violations of either the ICCPR or of the British Treaty. There's also no regional mechanism, by the way. East Asia is the only region in the world that doesn't have a regional human rights mechanism, unlike Africa, the Western Hemisphere, and Europe. China has not submitted to the jurisdiction of the International Court of Justice for resolving treaty disputes. So the UK couldn't go to this court in The Hague and complain that China is breaking its treaty obligations. So it can't be enforced that way. The UK could theoretically monitor, but there appears to be no political will in the United Kingdom to do that. What's left really is other nations in the world and civil society to criticize China, which is a common form of human rights advocacy, name and shame, to hold China accountable for its international commitments. More quickly, on the domestic side, there's the basic law. The basic law, in terms of substance, I can skip over pretty quickly because the basic law basically implements, to a certain extent, at least the fundamental rights portion of the Sino-British Joint Declaration. Article 39 of the Basic Law incorporates into Hong Kong domestic law the provisions of the ICCPR. Okay, so that part is set. The Basic Law is a little less good, as I've mentioned and as we've heard, with regard to democratic self-rule. Now, what are the processes for the Basic Law, and what is the Basic Law itself? The Basic Law is essentially, think of it as a statute of the National People's Congress. So theoretically, it could be repealed as a matter of Chinese domestic law at any point, but to do so would constitute a treaty violation and a violation of China's international law obligations. So it's got that degree of legal entrenchment, okay? Now, how is the Basic Law enforced? Well, as we've heard, the good news there is that the Basic Law provides for judicial review. So if the SAR government violates the human rights provisions of the Basic Law, that individuals can challenge those human rights violations before the Hong Kong judiciary, and the Basic Law grants the Hong Kong judiciary the right of judicial review, a la Marbury versus Madison. And the other good news is that the Hong Kong judiciary, at least for my money, is one of the best in the world. It is one of the best trained and most cosmopolitan judiciaries of any of the judiciaries that I've encountered in my travels around the world, including and especially the United States. In fact, I'd say including and especially the US Supreme Court, where I was a clerk. So that's the good news. The bad news is there is a loophole. which many of you probably know about. The loophole is Article 158 of the Basic Law says that, if the matter touches affairs that are the province of the People's Republic of China, in other words, if it's an internal matter, a purely internal matter, then the Court of Final Appeal will be the last word in interpretation of the Basic Law. But if it touches on matters of common concern to Hong Kong and China, then the Court of Final Appeal is not the last word. The last word is, in fact, the Standing Committee of the National People's Congress in Beijing. And as many of you probably know, the very first exercise of judicial review by the Court of Final Appeal, which was the right of abode case, where the Court of Final Appeal invalidated various ordinances of the SAR government for violating the right of abode, was overturned by an interpretation, I prefer to call it a reinterpretation of the NPCSC. Now, there was much worry in 1998, when that occurred, that the independence of the Hong Kong judiciary would be gone. Because if the NPCSC could just overturn rights decisions of the Court of Final Appeal in Hong Kong, where would judicial independence be? The good news is, as you've heard, the Hong Kong judiciary has retained that power and has done a very good job applying the Basic Law to challenges. I won't say I've agreed with all of its decisions, but its decisions have been well reasoned and certainly not out of line with what other similar courts would do interpreting similar provisions.
You just to let you know.
Right, okay, so that said, so let me finish by saying, but there is cause for concern, and the cause for concern is, even in the judiciary, we need to keep scrutiny. There was an important case where, and it was the first case, a case that's very complicated, it's a case called Congo, involving Congo, in which the Court of Final Appeal itself referred a matter that arguably was just within the jurisdiction of Hong Kong to Beijing. And so that bit of sort of preemptive surrender was not a good sign. It was the first time the court did it. Also, too, and I have to sort of full disclosure, this person's a friend of mine, but the most liberal judge on the CFA, Kamal Bakari, ordinarily the expectation was should have been renewed after he turned 65, and the expectation was most judges are renewed for another term. He was not, and indeed was replaced by a judge who was older than he was. And it creates the kind of concern, was it because he was one of the most aggressive judges in protecting? Now, I haven't gotten to what we can do about it. I'll just summarize that, and we can leave some of that for the Q&A, but I'll just summarize that by saying more of this. Keeping issues of Hong Kong alive in the international community, both in Hong Kong but also around the world. And secondly, not forgetting the legal piece. The law is not itself going to preserve Hong Kong, but Hong Kong does have these important tools that a lot of other places don't have. That suffer massive human rights violations. And so leveraging the legal tools that Hong Kong does have is something that you should familiarize yourself with and something that you should talk about and contribute to preserving. So.
Thank you for summing up so nicely, and I know that there will be questions that can bring forward more of your thoughts. So turning to the next speaker.
All right, I'm David Rezvani. I'm from Dartmouth College, and I will be talking about Hong Kong and partial independence. So before I get started, just to say that my area of research up till recently is partial independence. I have a book that's forthcoming the beginning of this summer. So you'll want to check that out if you're interested in the topic generally. But believe it or not, when I was a grad student, my original topic was the autonomous status of Hong Kong. And then it just got really carried away. And as time went on, I became more and more distant from Hong Kong. But I haven't lost track of it completely. So by returning to this topic, I am in some sense returning to my intellectual roots. So I'm glad that there's this conference, certainly. All right, so this is what I'll be doing today. First, we'll be talking about some of the controversy and fear over Hong Kong. Next, I'll be getting into 3 different schools of thought on the political and constitutional status of Hong Kong, the so-called dead autonomy school. We'll be talking also about the eroding autonomy school. And finally, we'll be talking about the school of thought that I personally favor, the real autonomy school. And then finally, I'll be testing some of these, some of my arguments. So, like some other speakers that you've heard at this conference, I will go back in time briefly. I'll go back in time to when I was a child. I was at home with my babysitter, of all things. This was the early 1980s, and on the radio, there was this report about Hong Kong and the situation there. I didn't understand. I don't know how old I was, maybe 8 years old or something. I was a child. So I was curious though, so I had my babysitter translate for me what was going on this report. And he basically said, look, there's this city in Asia, this great city, skyscrapers and things like this. It's ruled by the British, but pretty soon the Chinese are going to take over. And when they take over, they're going to destroy the city. They're going to destroy it. And so my eyes opened wide, and this was what I imagined. And I asked him, why are they going to destroy Hong Kong? And he said, well, they're communists. They're evil. Of course they're going to destroy Hong Kong. I said, oh. Now, nearly 2 decades have passed since Hong Kong has passed under its association with China. And some scholars continue to be pessimistic, perhaps not this pessimistic, but still pessimistic. And indeed, all over the news, there's pessimism and emphasis on the threats of Chinese usurpation of Hong Kong rights. Fears over Hong Kong. And so this gets us to the first school of thought, the so-called dead autonomy school. So proponents of this view, they assert that Hong Kong remains completely vulnerable to the unilateral fiat of Chinese authorities to make and unmake political institutions in Hong Kong. They emphasize China's overwhelming political and military resources, its unitary constitutional structure, its human rights abuses, and its existence as a one-party Leninist state that has the objective of maintaining the Communist Party in power by whatever means may be required. So dead autonomy proponents, they assume that China, according in the words of one scholar, does not really intend to maintain the Hong Kong unchanged for 50 years after July 1997, nor does it desire to preserve fully Hong Kong's capitalist system and lifestyle, whatever the 1984 Sino-British Joint Declaration may say on the matter, unquote. Put another way, as the press secretary of former Governor Chris Patten once said, he said this: there is no way on this earth that they are going to allow a high degree of autonomy in Hong Kong. And so theorists from this school, they also emphasize the necessity of a close reading of the Hong Kong Basic Law. And so they do this to determine the nature of the territory's autonomy and the possibility of a constitutionally entrenched status that might protect it from unilateral usurpation by the Chinese central government. Can I get a tissue? By the way, I have a cold, forgive me. So based on their reading, can you open that? Can you get me a tissue? Thank you very much. So based on their reading, When they pick up the basic law and they read it, they flip through it, what do they see? What do they see? Well, they see, and this was mentioned just a moment ago, they see, well, Hong Kong's basic law is an enactment of the National People's Congress. It's not an enactment of someone else. They also look around and they say, what's this? Article 158. The basic law can, according to this article, be interpreted by the National People's Congress Standing Committee. Case closed. So according to this view, its autonomy might look real, but it's not. It's dead. The next view is the eroding autonomy school. And so this view is also common among leaders and academics, and it says that Hong Kong's autonomy is partially intact, although it will wane over time and increasingly politically integrate with authoritarian China. So in 1999, when I was interviewing a member of LegCo, this member said to me that Hong Kong's autonomy would not end suddenly, but it would end by 1,000 cuts. Interestingly enough, Dennis is an expert on the torture of 1,000 cuts, but that's another topic. He was joking with me, of course. So, in accordance with this view, you have these eroding autonomy scholars, and some of them said this: there will be a qualitative change in SAR autonomy, undermining the very basis of one country, two systems, and Hong Kong's freewheeling capitalism. We don't have time to go into the specifics. You can read more about it in my article. I have some extra copies if you're interested. But one of the things they emphasize, one of the aspects of their logic is this. They say that over time, Hong Kong's autonomy will slowly erode because of China's increasing economic interdependence with Hong Kong. So as a consequence, they say, there will be over time an increasing institutional sameness. And this sameness will arise from the economic power of China as it continues over time increasingly to overshadow Hong Kong. Over time, according to this view, over time China's economic and political institutions will infect Hong Kong, that both the systems will eventually merge. So I was thinking about this recently on my drive over here from up north, and maybe it's because I've seen too many sci-fi films, but it strikes me that the eroding autonomy school is somewhat, they see Hong Kong somewhat like an astronaut that's become untethered from a space station, floating in space, about to die. For a time, the astronaut has some oxygen. Maybe the astronaut can talk with you a little bit and say some things to you, but they will die, according to this view. They will, I don't know what happens to you in outer space, you implode, something like this. So this is the view of the eroding autonomy school. So, fear not. At least in my view, these two schools, they're wrong. And there's a third way to look at things, more grounded in the reality of real Hong Kong. And so according to this view, Hong Kong is neither on a trajectory to lose its autonomous powers, nor are its autonomous powers dead. Instead, the real autonomy view asserts that Hong Kong is an example of a territory whose powers are robustly defended by political economic influence rather than constitutional influence. Hong Kong is a partially independent territory that shares and divides credible final decision-making powers with another sovereign state without being fully incorporated into a core state's domestic constitutional system. So most partially independent territories throughout the world, such as Bermuda, Iraqi Kurdistan, Scotland, Puerto Rico, Greenland, the historic British dominions, and nearly 70 since the 19th century, they have powers that are very difficult to take away. But in most of those cases, though not all, most of those cases, it's because of some sort of constitutional entrenchment. Some constitutional mechanism renders the promises that have been made to them very difficult to change. But that's not the case for Hong Kong. In Hong Kong's case, I would argue, Hong Kong's powers in the Basic Law are arguably defended by the political economic influence it exerts over China and its leaders. And this is the case because the fortunes of Chinese leaders, literally the fortunes of Chinese leaders, are linked to preventing Hong Kong's full political integration and sameness with the mainland. Since 1978, as most of you know, Chinese leaders and their supporters in the military and party elite have become increasingly tied to China's economic success. And Beijing is in many respects economically dependent upon Hong Kong. And indeed, what I'm about to say deals with some of the issues dealt with earlier or asked earlier in the conference. I guess you've already seen the statistics from Wei-Ping Wu's slide, but just to make sure you're awake, what is the #1 source of foreign direct investment into China in the world? Hong Kong. Hong Kong, and not just Hong Kong. Hong Kong is 41% between 1992 and 2008. By far, Hong Kong, by far. And it's not just on foreign direct investment, although this certainly is huge. Well beyond FDI, China is economically dependent on Hong Kong. We don't have time to get into all the areas, but this is certainly one powerful
Just to remind
example.
you, probably another 3 or 4 minutes.
3 or 4 minutes, okay. So, there are potentially disastrous outcomes for China in the event that are held at bay by sustaining the country's impressive growth. A growth that in many respects is influenced by its economic dependence on Hong Kong. Economic growth for the mainland placates popular unrest. It maintains selectorate support of lower-level military and Communist Party elite. It increases governmental capabilities and resources. And this view, this economic hegemonic discourse, you could call it, within China, it's come to dominate the central government institutional structure in terms of elite selection, demotion, and party policy. So let's talk a little bit about some statistics. Now, one of the major failings of the dead autonomy and eroding autonomy schools is that they provide little clarification on how it can be explained that since 1997, Hong Kong and China have experienced relatively limited political integration. So if the eroding or dead autonomy assertions were true, what could we expect? Well, we would look to the eroding autonomy and dead autonomy predictions. And what do they predict? They predict an increasing sameness between Hong Kong and China on a wide range of issues. But as you'll see, that does not bear out in the data. For nearly 2 decades since the British handover, according to the World Bank's governance indicator, each of these polities, China and Hong Kong, still maintain vastly different rankings. The World Bank's Worldwide Governance Indicator project is one of the most widely respected assessments of the progress of state governance, which has created indicators for 212 states and territories based on the perceptions of governance from 35 data sources from 32 different academic and policy-oriented organizations. So it's not like the opinion of like one person or one organization. Now, across the scope of these indicators, China's system has been held at bay by a great distance from merging with Hong Kong. And although it's, and so according to the World Bank's governance indicator, China maintains rankings on par with countries such as Malawi on corruption, Jamaica on governmental effectiveness, Uzbekistan on political stability and absence of violence, Uganda on regulatory quality, Egypt on rule of law, and Iran on voice and accountability. By contrast, in every category, Hong Kong far surpasses China, maintaining rankings on par with highly developed countries like Japan and Sweden. And there's other things I could say on this. Perhaps, since time is short, let's look at some time series data on this. So over time, we can see that since the handover, Hong Kong's autonomy has only increased. And I should say, before I show you this, when I was preparing for this conference, so I wrote this paper in 2012, but I was using 2008 data, okay? So with shaking hands, I went to Microsoft Excel to plot these lines, because I didn't know what the World Governance Indicator was going to say. You know, I thought, oh my gosh, what if the World Governance Indicator says the opposite of what I was been arguing? Then I'm really, screwed. But lo and behold, on political stability, this is the line for Hong Kong. Hong Kong increases, China decreases. On control of corruption, and by the way, the highest ranking you can have, this is like up there with like Sweden and Finland. Hong Kong is up here. Again, China is decreasing. So one of the things these two slides say is this: is China becoming less dependent on Hong Kong or more dependent? Is China in a situation where it could say, we have Shanghai, and you know what, in Shanghai, it's fine in Shanghai. It's fine. You go to Shanghai and do business. It's difficult to say that in light of this data. Governmental effectiveness, again, well, here China is going up a bit, but you see the gap between the two. Regulatory quality, Hong Kong can't go any higher. It's like hitting the ceiling. China is indeed going up. Rule of law, Hong Kong is going up. Since the handover, it is going up. China is incrementally going up in some respects. Right, voice and accountability in Hong Kong. Some of you might be saying, well, okay, wait a second. What about Hong Kong's media? Surely there's been some problems there, surely. And I acknowledge that's true. But there's one thing to keep in mind. Hong Kong's gap with China is huge. This is China. China's down here with Iran as far as voice and accountability, and it's decreasing. Hong Kong is up there, not with Sweden or Finland. So that's true. It's up there with Israel, according to the World Governance Indicator. And another thing, the trend line is going up since the handover. It's going up. Now, I'm out of time. There's more I'd like to say on this. Actually, to tell you the truth, this was like an 1 hour talk that I had to consolidate. But there's a lot more I want to say, and it's way beyond just these statistics. It goes to the 2003 situation where there was a controversy over Article 23. It goes to recent inroads, efforts by China that have been pushed back by Hong Kong. And just one final sentence I'd like to say is that this does not mean that everything is okay. It does not mean that Hong Kong, therefore, should just relax. Everything's fine. Everything's fine. On the contrary, one of the reasons why Hong Kong is the way it is, one of the reasons why Hong Kong has pushed back these efforts of China, is that the Hong Kong people are vigilant. They are worried. They are wringing their hands. So I would advise you to be vigilant as well, but take it with a grain of salt. Hong Kong is arguably has real autonomy. And if you're interested in my research, there's my article. My book is coming out soon, and you can always email me. Sorry.
With this information, you want to send it to the conference?
Yeah,
Oh,
sure.
it's there.
Yeah.
All right. Thank you. Now, aren't you all pleased that in fact all the speakers have spent so much time preparing for their presentations that they can't, squeeze it in 15, 20 minutes? I already have it.
Oh, yeah.
Good afternoon. Glad to be the person speaking just before dinner. I'm going to try to keep it short. I have plenty of data to share, but I don't have to go through all of it. if you're interested, we can always talk afterwards. I'll just briefly introduce my own background. So I have two primary fields. The first field is linguistics, which may sound a bit unfamiliar to some of you. The second field is law. So my research area is at some interjunction between the two fields. So there is such a field called language and law, and there are, within language and law, you have fields like forensic linguistics, or what you can see on CSI, or how do you use language as evidence. So there's interest in that. My current project is on legal multilingualism, so the phenomenon that there are legal systems in the world that operate in 2 or more languages. Now, why is that interesting, and how widely spread is the phenomenon? There are approximately 193 sovereign states in the world. How many do you think are bilingual or multilingual? Depending on what you mean by truly, I'll explain later in the talk that Hong Kong is not really truly bilingual.
Canada.
Right, yeah, everyone thinks of Canada. So there's Canada, there's Hong Kong, and then is there anyone else? There are actually a quarter of jurisdictions in the world are bilingual or multilingual. We're talking about 40-something at least. And there's like all these multinational kind of organizations and bodies, like WTO, like the European Union, African Union, and all these kind of international bodies that are also considered multilingual jurisdictions. So my research question, I started with a question of how do bilingual and multilingual jurisdictions deliver their justice differently, if there is any difference? So Hong Kong is clearly one example that I look into, but I actually do a lot of cross-jurisdiction comparisons as well, and that will be the material for my coming book. So that's the background. Actually, a lot has been discussed already in terms of legal background in Hong Kong, so I'm not going to get into details. Sino-British joint declarations, 50 years, no change, etc. I'll just mention that for 50 years, no change, which I wouldn't call as a promise, it is a policy. It focuses more on social and economic systems than on legal systems. In the Basic Law, these are things that the Basic Law say about the legal system in Hong Kong after the handover, which I won't read to you. But there are changes in the past 17 years in the legal system, despite the guarantee that we will keep pretty much the same legal system in the world. First of all, we have the Basic Law. That's an obvious change, which is considered by some as our mini constitution. The power of final adjudication has been shifted from the Privy Council in the UK to the Court of Final Appeal in Hong Kong. It has been mentioned by Martin earlier, cases involving reinterpretation and interpretation in Bretton Road cases, in the Congo case in 2011. So these cases challenge the independence and authority of the Hong Kong judiciary, etc. So these have all been discussed by the legal community and will not be the focus of my talk today. I'm going to talk about a much ignored change, legal language. And why is it interesting? Now, language is an identity marker, and choice of legal language is inevitably political. So if you look at Ukraine, what recently happened in Ukraine just last month, what the first thing that the new parliament did, the first legal change that they did, was to remove Russian as an official language in some of its regions. So that was how political it was. That was the first move they made after the political crisis. So languages are not only tools of nation building, but also means of political control. Now, in Hong Kong, there are currently there's. I've been following news of Hong Kong, even though I'm currently based in the US. Currently, in the education system, they've been talking about using Putonghua to teach Chinese language subjects and all other kinds of. Earlier, it was about 1 or 2 years ago, there were perhaps less than that. The education department posted this article on its website saying Cantonese is not an official language in Hong Kong. That stirred a lot of debate in the community. Is Cantonese an official language of Hong Kong?
Yeah.
And who says so? Obviously, we have someone with authority speaking, but in the law, if you look at what is written in the law, the basic law says, in addition to Chinese, English may also be used in the legal system in Hong Kong. So there's a sense of priority, first of all. In addition to Chinese, you may also use English. And the word Chinese is used in the basic law, also in the legislative level. There's no mention of the word Cantonese anywhere. So Chinese can become Mandarin at any point. And in fact, in the legal system, we already have cases that are heard in Putonghua, using extensively. Now, so my background is in empirical work, so I'm interested in how the legal system is actually working in Hong Kong today, as given the change in legal language. And this is interesting for two reasons. The change in legal language triggered rapid processes of localization of the common law after 1997. Secondly, it provides a window to dissect dilemmas facing the Hong Kong judiciary today. So that will be the focus of today's talk. A little bit of historical background. Law was mostly monolingual during the colonial days. This is picking up from what Michael was talking about in the morning. There were riots in the late 60s. At those times, protests were seemingly an effective means of political change. And this political change, on the second bullet point, says there was some form of limited bilingualism practice in 1974 that was a result of that riot. So they had Chinese become an official language on paper. That was only on paper because law remained an important exception. Law was still practiced only in English. Law was available only in English. Until there was the signing of the Sino-Joint British Declaration. It was only after then people realized that Hong Kong really have to be returned to China, so we really have to have the law translated into Chinese. So that was the start of legal bilingualism in Hong Kong, but not the end. Now, to start with, you think you have to have a bilingual system, you have to have your legislation translated into Chinese. So that was what they did. To translate everything just before 1997, as in a kind of mass production manner. And at the legislative level, Chinese and English statutes are equally authentic. So this is called the equal authenticity rule. I won't read you the titles of law. So I'm going to show you through a few angles, these 5 angles, like generally how the bilingual policy is embodied institutionally, use of Chinese in the common law system, how statutes are actually interpreted. Now that you have 2 versions of the law, can you rely on the Chinese text of the law to argue in a case? What happens when you have differences between a Chinese version and the English version of the law? Courtroom interactions, have they changed since the handover? Because now you can use Cantonese in the courtroom. And unrepresented litigation, there has been a sharp increase in litigants representing themselves after the handover. So people feel that because I can now use Cantonese to litigate, I don't need a lawyer. That's happening. And so we have about 120 hours of courtroom observation data on unrepresented litigation, and to see what's happening in Hong Kong courtrooms. And also, we will be using a comparative angle to compare with other bilingual and multilingual jurisdictions, especially post-colonial territories. Institutional embodiment of bilingual policy. Hong Kong is a very young bilingual jurisdiction when compared to, say, Canada and other places. There is still a lot of systematic asymmetry between the use of Chinese and use of English in Hong Kong. I would go as far as saying that apart from having all legislation translated in Chinese, so in that sense you have a bit of a balance. Apart from that, there is no balance of any sort between the use of 2 languages in Hong Kong. The trials may take place in either Chinese or English, but cases tried in Chinese tend to cluster at the bottom of the court hierarchy. So if you think about court hierarchy as a triangle, if you go to magistrates court, district courts, they're almost all Cantonese. If you go up higher courts, they're almost exclusively English. So lawyers in Hong Kong would argue that for points of law, it's better to argue in English. For, if you just want to get the facts, it's quicker to use Cantonese. So it's a very pragmatic way of using the languages. So there's a clear functional division there. Judgments, for the same reason, judgments written in Chinese are of little reference value. So imagine if you were a litigant in person, or unrepresented litigant, or pro se litigant, like this is all different terms for the same concept. If you're representing yourself, and if you don't speak English, if you don't understand English, and given that in a common law system, case law is so important, it's part of law, and you don't have the cases translated, available, important in Chinese. How are you going to go about doing it? So I have some statistics here, which I won't read. Only a very small amount of judgments are available in Chinese. Legal education reference books are offered mainly in English. If you go to any university in Hong Kong that offers a law program, it's mostly in English. Like at Hong Kong U, my home institution, I think in City U as well, you have like one course that teach you using Chinese in the legal system, and then everything else is English. And then everything else that is available in Chinese are electives. Last point, even though the system is bilingual, not all legal personnel are. Like even for lawyers who come from Hong Kong, often they went to Oxford for their education, for their legal education. They're completely fluent in arguing in law in English, but maybe not so in Cantonese, especially for those who were trained earlier. Common law Chinese, and this is also a response to Martin's question earlier, in terms of progress we made in bilingual process. Now, common law Chinese is not just a translation, but an invention. They had to coin a lot of new terms because common law Chinese did not exist. We didn't have the vocabulary to describe English common law concepts in Chinese. You cannot just borrow existing terms from China or from Taiwan because it's a different legal system. So that would be very confusing because the concepts are different. So you have to invent new terms in order to do the translation. For the same reason, if you read any official Chinese legal texts, I don't know how good your Chinese is. One of my majors at university is translation, so I would say my Chinese is not too bad. I have no idea. I mean, I'll show you in the next slide. Especially the text in italics that I have particular difficulty with. Now, this is not a text written for legal professionals. I picked this up from a leaflet for a center set up for unrepresented litigants in Hong Kong. So these are texts written for laypersons to explain to them what the law is like, what you should do, and how you should proceed if you want to litigate. Like 應由語以令狀展開觀眾. I mean, I can't even parse the text to start with, even despite my linguistic and legal background. I can't even tell which words are a verb and which words are a noun. Seriously, in the last example, if you speak Chinese, and then last bullet point, can you pronounce that word? That's tickling. So I looked it up. One methodology in linguistics is called corpus linguistics. You can look up words or sentences or structures in language database to see where they come from and all of that. Tickling does not exist in modern Chinese. It's from ancient Chinese. And they somehow borrowed that ancient character into current law of Hong Kong. Anyway, you get the point. So common law Chinese is very foreign to local. So if anything, this has nothing to do with access to justice. So you're asking me about how the translation would have improved access to justice. When they did the translation, access to justice was not something they had in mind. So if you here's a quote from this is a professor working in the US called Ng Kwai-hung. He published a book on legal bilingualism in Hong Kong. If you ever want to look him up. He said the prerogative of the exercise was not to make the laws of Hong Kong in Chinese accessible, but to preserve the Englishness of the law in Chinese. In fact, I mean, I don't know whether I put it in this slide. Yeah, this is actually acknowledged in a government paper. It's an open secret. So in the government paper it says, the common law will in future underlie the Chinese text of the laws in Hong Kong in precisely the same way it does the English text. The consequence of this is that the meaning of the Chinese text in the courts of Hong Kong may not be what the reader unfamiliar with our legal background may think it to be. So you read this Chinese text, you think it means X, it may not mean X. This is what the text is telling you. So, nothing to do with access to justice. Bilingual statutory interpretation. So I told you about the equal authenticity principle. So you have the English text of the law, Chinese text of the law, they're supposed to be equally authentic, meaning they're supposed to have equal power. You can't say that because English started earlier, then you should look at English instead of Chinese. At least this is the principle. I won't have time to go into details of cases, but I did some extensive comparisons of if the same principle applied in Canada, same principle applied in the European Union, and found very divergent practices as to how we actually apply the principle. Now, first of all, you don't have to use the principle. So in other bilingual and multilingual jurisdictions, you can decide that, okay, Chinese is more important because it's politically more important in Hong Kong now, but let's place it above English. Or you can decide that because English is our bridge to the common law system, we should place English above Chinese. But that's a very politically difficult decision to make for Hong Kong. So it's a matter of compromise, you just make them equally authentic. Let's not make a decision about this. The result of that is that, for the judiciary, it has been very difficult when you have two texts that are actually divergent. I would argue that in all the cases that I've found where divergence is found between the Chinese text and the English text, the judges actually preferred the English text. This may sound unsurprising, but it's against the principle of equal authenticity. It's different from the intention of equal authenticity rule. There's also an incidental consequence of this, which is that because there's more linguistic indeterminacy, meaning uncertainty. So originally, when you have indeterminacy exists in the law, even in monolingual jurisdictions. So difficulties as to what this word means is what mostly has been argued in legal cases. But as compared to monolingual jurisdictions where they have intralingual indeterminacy, now we have interlingual indeterminacy as well. So there's increase in indeterminacy and there's increase in judicial discretion. I'll just run through very quickly. I won't explain the details of the cases at all, but I just want to give you the difference in spirit in how the rule is applied. This is a Canadian case, quote from a judge. At the hearing, both parties focused on the English version of this particular law when they argued the meaning to be given to the provision, but the court must consider the French text as well, for it is equally authentic. So this is when, in Canada, someone was arguing a case based on the English text of the law. Now, try that in Hong Kong. Bring up a case, bring up the English text of the law. The judge will never say, oh, let's look at the Chinese text of the law as well because it is equally authentic. It's hardly ever happens in Hong Kong when you start with English. Now, if you start with Chinese, they will bring up the English text of the law to see what it's supposed to be like. This is an international law case. I'll just read this one sentence. The early international practice of referring to the original text as an aid to interpretation is incompatible with the equal authenticity principle in some international treaties. So this is where the equal authenticity principle comes from. So you don't say that this is original, this comes later, that's why you should look at the original. The point of the equal authenticity principle is to remove that kind of historicity. Now, Hong Kong case. If the ordinance was initially enacted in English, the English text was the original official text from which the Chinese text was subsequently prepared and declared authentic. In ascertaining the ordinance legal meaning, the English text should be taken as more accurately reflecting the legislature intent, blah, blah, blah. You see the difference in spirit. So that's the point. I'll move on to courtroom interactions. Done some courtroom observations. Now, using Cantonese in the common law courtroom is completely novel. First of all, it's a dialect. It's not a formalized, standardized language. It's highly colloquial and fluid. There's little standardization. Hong Kongers love to code mix. All of that has entered the courtroom in Cantonese courtrooms. So you have this orderly shouts, this is from early research, in volcanic emotions, little regard for English formality, rules, and procedures. Now, bear in mind, common law system, like a typical formal English courtroom, formality is extremely important in a common law system. You maintain distance, you assert authority based on that distance. Now, when Cantonese comes in the picture, that formality just dissolves. So I have an earlier paper, which I won't have time to go through with you, if you're interested, just look it up, that documents how even judges talk differently. Now, before the handover, you never hear judges talk in Cantonese, even if their mother tongue is Cantonese. Now they can talk in Cantonese. So I've had documentations of exchanges between judges and litigants and defendants that you would never imagine happen before the handover. So I would argue, I would go as far as saying that the whole legal culture is changing because of the introduction of Chinese. And there's reduced psychological distance between law and people. I'm representing litigants. They overwhelmingly choose to pursue their cases in Cantonese. A couple of reasons for such legal mobilization. Because of the bilingual policy, obviously. Also because of a weak legislature, so that power is transferred to the judiciary. There's evolving legal consciousness. The public have now higher expectations from the government than before. So for a combination of reasons, there are more people who are willing to go to court without the lawyer. Some statistics, this is mostly in civil trials. There are a lot of, and in district court, there are a lot of similar data from the LegCo that you can easily look up. But we're talking about more than half of the cases, of civil cases. So that's a very significant amount of cases involving self-representing litigants. So I'll just jump to summary and conclusions. So where did the changes lead us? Inclusion of Chinese provided symbolism of sovereignty change, nationalism, so we know that it's a necessary change. But it coincidentally triggered processes of localization. So in a way, the legal system is going in a different direction because of the bilingual policy, in a different direction than what the larger society is heading towards. Because the British common law system is localizing in Hong Kong. It's becoming more Cantonese than ever, at least in terms of courtroom interaction, not so much higher level law debates. So there's a contrast with popularization of Mandarin in wider society and other forms of assimilations that we have talked about. It's a bit of a paradox of the one country, two system. So we're talking about, say, in the example that I gave you on bilingual statutory interpretation, we have only adopted the bilingual policy half-heartedly. I was also talking about the asymmetry and all of that. In Canada, they would, because they see bilingualism as a long-term policy, so they have a lot of other facilitative kind of measures to help establish and make sure that you say all Supreme Court judges there would have to be bilingual, their education system, legal education has to be bilingual as well, so there will be all of those measures. But in Hong Kong, other than getting the laws translated, there hasn't been much momentum in making the Hong Kong legal system in Hong Kong truly bilingual, because there is no incentive. This echoes what Charles was saying last night, which I think is a good summary of what we've talked about in this conference so far, is that in general, we have this demand-driven kind of approach to problem solving in Hong Kong. So at the handover, because you needed to add Chinese as a legal language, then you add Chinese, because you don't want to make a decision about which language should be more important in the legal system, just skip them both. There's a lot of decisions made like that. So further to more important questions about where the legal system can be going in the future in Hong Kong, I guess both the bilingual policy and the larger legal system in Hong Kong have this transitional existence, this existential problem, because they don't know where they're going. So what happens if you become truly bilingual, and then you just merge your legal system with the Chinese one? Nobody knows. And this makes the Hong Kong case a difficult comparison with other post-colonial jurisdictions, because in most other cases, these jurisdictions become independent after the colonial rule. So the Hong Kong legal system is inevitably caught in power struggles. The judiciary is under pressure to stay connected to the English roots, both to achieve social justice and to remain independent. The Hong Kong judiciary has a very special role in that, actually I'm stretching kind of beyond what I've been showing you. It's a very special, it's an unusual system in China. You have an independent judiciary operating in a foreign language plus a dialect, never to be seen anywhere else. people's faith in and awareness of what can be achieved through the courts have also been changing. And finally, I'll probably just conclude on this point, that the rule of law has become an important rhetoric in post-colonial Hong Kong. I'll probably write in my next paper on this topic because I'm fascinating, but now we have been, mostly by speakers in this conference, we've been using the rule of law very positively as a kind of goal to achieve. That falls into the first category. So locals use it to distinguish Hong Kong from its motherland. We talk about core values and all of that. On the other hand, you have, if you look at Wen Wei Pao and other pro-establishment kind of newspapers and media, they also use the concept of rule of law, no less than what Democrats do, just for a different agenda. The rule of law as a concept itself is so fluid, it could be used either way. I'll probably have to open up for discussion for now. Yes.
Great. So Larry just told me that we could have a little more time.
Depending on the audience, yeah.
Depending on the audience, okay. So why don't we actually turn it over to Dennis to give some minutes of comment, but we really do want to have some time for questions. Dennis.
Thank you, Margaret. I'll be extremely brief, but I do want to respond to some of the really interesting comments and observations by a distinguished panel of speakers. First to Martin. He mentioned international community observation and monitoring of how well Hong Kong is doing. I never have much hope in what the international community would do for Hong Kong, frankly. Not because there are not really passionate people like Martin out there who really cares about Hong Kong. It's because British government or indeed the US government cannot be banked on, or we cannot lay our trust on foreign governments to help fight our own fight. Hong Kong people has got to fight our own fight in fighting for our freedoms and democracy. And relying on the British government, seriously? Sorry, but if they had introduced democracy much earlier, we wouldn't be in the situation that we are in now. It's really the British who left it to the last, the 5 years of colonial rule to start introducing democracy. Too little, too late. I think it was Benjamin Franklin said that if you count on the British to do the wrong thing, they will always do the wrong thing. So I personally don't pay much attention to what the reports of the British government Foreign Office say, and that is laid in Parliament every 6 months, and especially the way it is written. I passionately believe that Hong Kong people is going to fight its own fight. And on interpretation of the basic law by the NPCSC, there's a recent development whereby there is a very controversial foreign domestic helpers case which concerns their right of abode. It was very controversial that people in Hong Kong feel that these foreign domestic helpers should not have a right to apply for a right of abode in Hong Kong, and then it was very controversial. There's a huge pressure on the CFA to seek an interpretation of the basic law from the NPCSC. And the government duly made a request during the litigation while it was at the CFA, and made that request that the CFA refer the case to the NPCSC for an interpretation, and the CFA say no. They say it was not the kind of case that requires an interpretation by the NPCSC, so we're not going to refer it. And then the question becomes, is the government going to refer it itself, refer the case by going above the CFA? But they didn't, because the community, especially the political pressure, was so huge that the government didn't dare make such a constitutional move. Now, I hope this case would sort of set up a good precedent for future cases whereby the government do not go over the court's head to seek an interpretation. Rather, you ask the CFA to decide whether they need to seek an interpretation from the NPCSC, and the CFA will have made, there is already an established set of principles whereby the CFA will ask itself whether the criteria for an interpretation has been satisfied. And the answer is no, they will not refer it. So I hope this will establish a good legal tradition for interpretations in the future. there's some talk about competitiveness in the earlier panel, which I also want to briefly comment on. Hong Kong will, I don't think there's been much mention about the environment issue. A lot of my friends who moved up to Shanghai and Beijing 10 years ago to work are all coming back to Hong Kong. Especially, they've reached an age where they have kids now. And it's just impossible to raise kids in Beijing and Shanghai. Not impossible, I mean no disrespect to the parents there, but it is hard, especially with the air pollution, food safety issues. It is no, it's no coincidence that people come to Hong Kong to buy milk powders because you can't even trust milk powders you buy in China. And the air pollution is so bad that, these are competitive issues for Hong Kong that you can't just look at hardcore sort of systematic or economic factors. These are social factors or environmental factors that will affect Hong Kong's competitiveness. And the air pollution in Hong Kong is not perfect. We're not Switzerland, but it is much better. And it is because the laws regarding air pollution are observed and enforced by the authorities. And I think we have an edge there. Again, Hong Kong is a society where I hope to see it will become even more livable compared to other parts of the region, so that we continue to attract the best people to come and work in Hong Kong, especially for the legal community. Now, Janny's thesis is really interesting. I've never really thought about that issue between Chinese English in that depth. Of course, for my practice as a lawyer in Hong Kong, I have used both languages in the courtroom. And it took me a while to get used to using Cantonese in the courtroom because, as you said, the mother tongue of the common law is really English. And I don't think you can ever divorce English language from the use of the common law system. But what do you do? 99% of the population in Hong Kong are Chinese, and a lot of them don't like to use English. I think that the problem can be addressed in several fronts. First of all, you need to hire better Chinese drafting experts in the Department of Justice, where there is a serious lack of such people at the moment, and they admit it. And that's why the laws are some of them are so badly drafted in Chinese. And the problem is because they write in English first and then translate it into Chinese, and that would never work. The second thing is you have to reduce the number of unrepresented litigants. You can't say, there are 40% unrepresented litigants in Hong Kong. It's not because they feel like they can now litigate on their behalf. My experience is because of financial issues. They don't qualify for legal aid, so we need to address the legal aid system. And we need to ensure there are more lawyers who could represent people. I think given a choice between representation and self-representation, I think most people will always choose to have a lawyer to represent them. So we need to address the problem that way. Just an interesting point, I note that the basic law actually is also in two languages, right? Chinese and English. But the Chinese actually takes precedence over the English version. Now, correct me if I'm wrong, I don't think there's ever been a case where there's a direct conflict between the English version of the basic law and the Chinese version. But if there is such a conflict, the Chinese text will actually prevail. And but I'll see whether, I don't think there's actual conflict in real life, but we'll see. But anyway, I think back to the final point, sorry. Yeah, final point about Cantonese being official language. I'm a real passionate believer of Cantonese. We have, as a language, as it is a language, that we have such a longer history and tradition, right? Don't we, as Cantonese, than Mandarin? It goes way back. It's a much older language, much longer history, and it's spoken by people around the world. So I don't know why people start questioning whether it is a language. Of course it's a language. There's a recent experience where I was invited to a debate in Hong Kong, where the Dean of Law from Tsinghua University came down to, they want a sort of a discussion debate on basic law. And the organizer called me up and said, "You're going to speak in Mandarin, right?" Well, no, I'm not going to speak in Mandarin. Because first of all, if I speak in Mandarin, I don't think you can find a translator for me. Secondly, I said, look, we're in Hong Kong, okay? So the professor you can find a translator for him. I'm going to speak in Cantonese because there's no way I'm going to debate with him in Mandarin. Lose. Anyway, you want to make a...
Yeah, just quick comments to your comments. I mean, I don't know the exact number, but I've come across one case in which the judge commented on if there is really such a difference between text of the basic law in Chinese and in English. Chinese would prevail. It is in the judgment, but the case itself did not deal with that particular term. And on
provision in the basic law where they...
Yeah, it is in the basic law. So
conflict.
right. So at the level of basic law, if there's conflict, Chinese prevails. But at the level of legislation, it's equally the two texts are supposed to be equally authentic. For underrepresented litigants, you are completely right in that financial reason is the number one reason that my interviewees cited for going to court without a lawyer. But they also feel that they could, now that they don't get financial aid, deciding between not going to court and going to court but doing it by myself in Cantonese kind of helps them make that decision to go to court.
Any other responses before we open it up?
Yeah, just very quickly. I mean, and God knows, in light of March 17th coming out, I am the last person to put any faith in the British government. And in fact, my point was there was no political will in the Foreign Office to monitor, even though they had the legal right to do so. And I further agree that whether you're talking about Hong Kong, Belfast, Kuala Lumpur, the most important variable when it comes to implementing international human rights or domestic human rights is how the local population fights for it. And I think we heard that was an enormous factor for Hong Kong's lines keeping going up. That said, I think that you leave on the table a very important tool if you do not reach out to international civil society and even to other governments for help in monitoring, capacity building, etc. When the right of abode controversy came out, internally, as I say, the quality of constitutional argumentation by the Hong Kong Bar and by the Court of Final Appeal was stunning. That said, once the reinterpretation came down, there was massive global attention on that. And one hopes that at least in part, that pushed back a little from those in Beijing who thought, well, gee, we can do this all the time and we'll do this all the time. So, I don't think it's an either-or choice, domestically fighting for human rights and, reaching out to, the rest of the world. And indeed, I think exactly this, both, bar exchanges, academic exchanges, etc., are very important. And in fact, one final thing, getting back to Singapore, is Singapore actually has been very smart in throwing money and subsidies at US and other Western universities. And I actually raised this with some Hong Kong officials. Hong Kong is not. And that's why you had Yale and NYU and others locating campuses in Singapore and actually curtailing student free speech to do so. It seems to me if American universities are interested in locating in a gateway Asian city, do one where there is academic freedom and do it where there is free expression. And I think the Hong Kong government has somewhat missed the boat in not being as aggressive as Singapore has been in trying to get some of that market.
We just got Chicago to come from
Good.
Singapore.
Yeah, that's great. That's great. That's it.
Okay.
I have to be called by the chair first.
Oh, no, go right ahead. You got the mic.
I'm Evelyn Hootie Hart. I'm on the faculty here, and welcome back, Margaret.
Oh, yeah.
It's good to meet you later. But I had to leave for a little while today because the Latino student alum are also meeting, and my field here in history is Latin American history, so I know Spanish and Portuguese, but I want to make some quick comments. This evening, Michael Sun and I are going to moderate the evening discussion, so but I just have a burning question I have to ask. First though, to Dennis, you know, Cantonese is not only a real language, it is the authentic Chinese language. You can't read Trump poetry in Mandarin, it doesn't make sense. Poetry, it has to be read in Cantonese to sound like a right. Yes. So, but also, you know, in Singapore, they have given up Hokkien. They have traded that for Mandarin because Lee Kuan Yew speak Mandarin campaign. And I was in Singapore recently, and they so lament that. And the Malaysian Chinese are gloating because they say our Chinese is better now because we have retained our Hokkien and knowledge of Chinese in Chinese schools. But not only that, Singapore uses the Jiantizi. They use simplified characters now. That's how much they've given up. So, Taiwan and Hong Kong, hang in there because it's the last bastion of the Fantizi, the Chinese culture that is embedded in the language. But for Janny, I do have a question. You know, today we made reference to Singapore, a little bit to Taiwan, but where is Macau? You know, Macau is different from Hong Kong, even though they have the same basic law and all that, and the bilingualism. But hardly anybody in Macau speaks Portuguese. That's the difference. That is a real difference. I speak Portuguese. I go to Macau. I can't find anybody to speak Portuguese. Not even in the National Archives, the Arquivo. Nobody there speaks Portuguese. So things must be different than in Macau because all that Portuguese that's everywhere because of the law, basic law, nobody understands it, nobody cares, nobody reads it. Just the opposite from Hong Kong. Do you want to comment a little bit on that, using the language politics and the bilingualism? Okay.
I'll just confess that I haven't really looked personally into Macau, but it's on my list. So I'm working on a list and I haven't got to Macau yet.
Yeah.
But certainly they have the same issue. And in fact, I was talking about the number of bilingual multilingual jurisdictions in the world. We're talking about 40-something. If you look at the geographical distribution of these jurisdictions, they are mostly post-colonial. So there is, apart from, on top of having two languages, there is also the difference in language status, the difference between a foreign language and local language, the kind of language politics that go on that will apply in exactly a similar way
you know
to
what's a
Macau.
very good, interesting example is Mauritius.
Mm-hmm.
Mauritius has 3 official languages.
Yep, and South Africa has 11.
And now native
Yep. Yep, and
Yeah. Before I recognize one other question, I think we have a response to.
Yeah, actually, I just wanted to quickly respond to something that Dennis had to say. He was mentioning, I don't know if this was a criticism, but he said that we shouldn't just look at big macro statistics. I think on Hong Kong it's important to also look at qualitative examples. So for example, if I told you that I have an invisible force field around me, similar to Hong Kong having a force field around it, protecting it from China, arguably, then I would want you to test the force field. I would want you to take a pen and throw it at me and try to hit me. And, you know, don't do that because I don't have a force field. But if I did, it would bounce off me. So what are the test cases that we can look at with respect to Hong Kong? And there are many. It's not just the Article 23 issue where 500,000 people got on the street and you have all sorts of resignations and all this stuff. It's a lot of recent issues. You have the national education issue, you have immigration issue, you have the baby formula issue, you have the baby tourism issue where mothers from the mainland come in, they want to have their children in China. In all of those cases, it's like a dam that's blocking China, and it's been patched in every one of those cases. So that's all I have to say.
Back there.
Let me speak a few Cantonese. 我係唐人，我來自唐山，我講唐話，我寫唐詞，我中意去唐人街食唐餐。Senhora, bondade, eu falo português, mas esqueço.
Ah, você fala
Natural and Macau. Right here, we have a lot of Americans here, but there's a U.S. law passed in 1991. There's a U.S. Policy Act. It's monitoring Hong Kong situation. I would like the speaker mention about the U.S. Policy Act. You don't familiar?
So are you talking about the delinking of MFN status with?
No, no,
or-
yes. May I?
Yes.
Yeah, go
Okay,
ahead.
since I work for Congress.
Yeah.
Yes, there is the U.S. Hong Kong Policy Act. And it basically.
Oh, that,
right.
yeah.
Okay, I was actually going to bring it up to the panel, because it's, Dennis, with respect to that. There was a U.S. Hong Kong Policy Act, 1991, very good. It basically states what U.S. policy is with respect to Hong Kong. It's very interesting in how that it's written. Basically what it says is so long as Hong Kong remains highly autonomous, all the international treaties that we have with it and its separation as a customs territory, so on and so forth, will be respected. Here's the weird part. If the autonomy goes away, we're going to treat you just like the mainland. So it's sort of like, if you got a problem, we're going to punish the victims. Now, what's interesting in an interesting provision, you mentioned the international monitoring. The law had provisions for the monitoring to go on. There's a requirement in the State Department every year to report to Congress about how well Beijing, the Beijing government, was respecting the autonomy of Hong Kong. It only went through a certain period of time, and Congress each year routinely would extend it for another year or two as part of an appropriations bill. What happened a few years ago is we never passed an appropriations bill. And so that provision lapsed, and it has not been re-implemented since. So the State Department no longer has to report on the status of Hong Kong with respect to its autonomy. And it's not because of a decision by Congress, we don't care anymore. It was because Congress failing to pass an Appropriations Act, which is the normal vehicle for which it was put into the law, didn't happen. But I'm going to use the microphone real quick. Jenny, I love your presentation. There's a great videotape going around a few years old where they go on the streets of Hong Kong and they ask students, university students as well as people on the street, to translate using purely Cantonese. You know
I know
the
the
one.
researcher.
You're the researcher?
I know the researcher.
Okay, to translate into Cantonese a phrase that any university student knows. I can't remember what is it.
Project. What is it in Cantonese?
Chinese.
Ooh, file.
Oh,
Oh, that.
okay, but it was funny. You're doing quite well. I think you're going to say it's like tomorrow I have to present a project to my class, something like that. And one after another, the Cantonese speakers would get up to project and fumble. They had no idea, no way of translating. But getting to when the process of transforming, well, another quick anecdote. I had a long debate after the standing committee gave its decision with respect to 2017 and 2020 about 可以 or 可以 and what it means and whether that's a promise or not. Now this is a second and third language for me, but that kind of discussion was up. Getting back to the Chinese that is embodied in the Hong Kong laws. The grammar structure of Cantonese and Mandarin are different. Which one is actually, which type or style of Chinese is embodied in the written text?
The answer is it is anglicized Chinese. It's not Cantonese Chinese or Mandarin Chinese. It's English Chinese. The structure is English.
So they created a whole new Chinese.
Seriously, the structure is English. If you look at the structure of legal Chinese, that is.
Could I just throw in one thing about monitoring by the U.S. government? Because there was the lapse with regard to those autonomy reports, but there are still two sources where there is ongoing monitoring. One is the State Department country reports, which the State Department puts out annually, usually January, February, monitoring every country in the world with regard to how they adhere basically to ICCPR kind of classic negative rights. And in the China report, they have separate sections on Hong Kong, separate sections on Macau. And that is something that the Bureau of Democracy, Human Rights, and Labor does every year. There is also another entity called the Congressional Executive Commission on China, which produces an annual report. And its job is to report on China-related matters, especially with regard to the rule of law for both Congress and the executive. And it produces a very detailed annual report, which also will deal with Hong Kong as well. So, so that's examples of some monitoring. That said, I think my larger point is, for various reasons, Hong Kong, I think, has dropped off the radar screen of a lot of human rights organizations, a lot of NGOs. And I think partly it's because a lot of folks have bought into at least the eroding autonomy model, and and I think also in part because China itself sucks up so much oxygen out of the room when you're doing advocacy. But I think that's not a good thing, even though, again, primarily it is up to the people of Hong Kong to guard their rights, and they've been doing actually a magnificent job. Assistance from the world community doesn't hurt. It's like chicken soup, as we say in New York, and that needs to be revived and re-energized, I think.
This is more, I guess, a technical question, but the previous kind of about mainland integration into Hong Kong, and more mainland immigrants arriving in Hong Kong, more and more mainland companies establishing subsidiaries in Hong Kong. So with the ambiguity of Chinese in the Basic Law, has there been any movement where companies will try to use spoken Mandarin in courtrooms in Hong Kong, or is that not the case?
It has been used. Mandarin has been used in Hong Kong courtrooms. I found some, it's a very minority of cases, but it has been used. Even judges and interrogation has taken place in Mandarin. And in some of the courtroom observations that we did, and especially in the very bottom of the courtroom hierarchy, there is the interesting question of, if you have a witness speaking in Mandarin, do you interpret for him if everybody else understands Mandarin in the courtroom? I mean, normally you would, but I've seen quite a lot of examples where, because people understood already, they don't wait for the interpreter, they just jump into the next question. So there's a kind of uncertainty about what the status of Mandarin in Hong Kong courtrooms, but it has been used.
Larry, what? One more? All right, one more.
Yeah, you have the mic.
Well, yeah, I wonder.
Well, but I actually.
You've already spoken, so
sure.
I usually like to. Anybody who haven't spoken and would like to ask a question?
So thank you for coming here today. Just have questions on the practicability of one country, two systems. So we all know that the Chinese liaison office, government liaison office, is now meddling in Hong Kong's affairs at all levels. And basically we have no say in the formulation of electoral methods in Hong Kong, as Hong Kong people. So do you think the system still works, the idea still works for Hong Kong, one country, two systems? So, because it is very important to us, because even though we have democracy in the future, if the Chinese government still meddle in our affairs, democracy is not going to work. So I'm really concerned about that.
$1 million question.
Yeah. I think the Chinese government, the basic law, the legal position is that the basic law states that no department of the Central People's Government can interfere into domestic affairs of Hong Kong, but that's the law. And lawyers are pretty useless when it comes to actually maintaining what the law is supposed to maintain. But, I think the Chinese government or whatever department, the China liaison office, will always try to meddle or interfere. It's really up to us to decide whether we allow them to. My colleagues in LegCo, not Charles or me, but some of my other colleagues in LegCo will get a call from the China liaison office every week telling them how to vote. But they, whether they listen to them is a matter for my colleagues. But if you don't let them, dictate how you're going to vote in LegCo, or what cases you take on, or as a lawyer, or whether you report on something as a journalist, then they can't. I don't think we're in such a helpless situation where we are inevitably going to be interfered by the Chinese authorities. It's a question of whether we let them. And so far, things are not hunky-dory, but it's not so bad that the Hong Kong people really don't have a say over important issues. We still do. And we need to continue to fight so that we ensure that the will of the Hong Kong people will continue to dictate our public affairs.
Right. That help? And,
I
okay.
have a reaction.
Okay.
So, I think Hong Kong is legally vulnerable to the legal fiat of China. Some people argue that, like I discussed in my talk, some people say, well, let's look at the basic law, or let's look at what the Final Court of Appeal says to determine whether Hong Kong has autonomy. As if something they might say, or something that might be in the basic law, would protect Hong Kong. But even if there was, not only are those things not there, they don't even have the potential to protect Hong Kong. China does not obey its own Supreme Court. Why would it obey the Final Court of Appeal? China does not obey its own 1982 Constitution. Why would it kowtow to any provision in the basic law? It won't. So if there's going to be any way for Hong Kong to be protected, it's going to be from some other means. And I would argue, and this is based on empirical evidence of the past. If you look at, for example, at what happened after China really tried to change some of the rules in the summer of 2003, when they tried to push forward Article 23 legislation, you have large numbers as a consequence, not only people taking to the streets, but you have large numbers of significant numbers of high-level resignations. You have the leader of China coming and giving a talk to Hong Kong, not berating them. Why didn't you pass Article 23 legislation? Not even mentioning it, but rather saying there should be stability in Hong Kong, mentioning the economy 30 or 40 times in his speech. This is just a few hours, a few weeks after the Article 23 issue. So if you look at what has happened so far, you can see that there are these events. China is scared to death that something might happen to Hong Kong that will cut off its ability to act as the engine of economic growth for the Pearl River Delta, as well as southern China, as well as the whole of China. And if that economic engine turns off, China is in a lot of trouble. So I think that protects Hong Kong.
Okay, well, I think dinner is waiting for you all. It's 6